From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The latest legal theory against Donald Trump is that he's disqualified from being president again under the 14th Amendment, as the latest Wall Street Journal poll finds that his support in the Republican primary has risen to 59%. Welcome, I'm Kyle Peterson with the Wall Street Journal. We are joined today by my colleagues, columnists Kim Strassel and Bill McGurn. Passed in the years after the Civil War, the 14th Amendment includes a disqualification clause aimed at former Confederates, and an argument that's now gaining currency in the national discourse is that this language might also apply to President Trump. Let's start with a clip of Senator Tim Kaine of Virginia. This is him on ABC yesterday making the argument.
The language is specific. If you give aid and comfort to those who engage in an insurrection against the Constitution of the United States, it doesn't say against the United States. It says against the Constitution. In my view, the attack on the Capitol that day was designed for a particular purpose at a particular moment, and that was to disrupt the peaceful transfer of power as is laid out in the Constitution. So I think there is a powerful argument to be made. My sense is it's probably going to get resolved in the courts.
And here is one of President Trump's Republican rivals, Governor Asa Hutchinson, last month on CNN.
There should be a court declaration, and so there would have to be a separate lawsuit that would be filed in which there would be a finding that the former president engaged in insurrection, and that would disqualify him. That's one avenue. The other way would be that if a specific state made that determination on their own, then that would put the burden on someone else challenging that. Either way, it winds up in court for a specific finding. But I expect those lawsuits to be filed. I expect some states to take that action. But I think it's a serious jeopardy for Donald Trump under our Constitution not being qualified.
Kim, what do you make of this argument?
I would call it dangerous overreach. First of all, let's look at the actual history of the 14th Amendment. Obviously, it was passed in the post-Civil War period. The amendment was very much designed about enshrining equality, but it does include this Section 3, which was aimed at Confederate soldiers who had taken up arms against the Union. And while it was used quite a bit in the aftermath of the immediate Civil War, since the very late 1800s, it's only been used twice, at least according to some press reports. And so this is something that people are digging up out of the past. I think that not only is that a dangerous idea because, once you establish something new as a precedent, how can you use it against other people? It will be used for partisan purposes on both sides. But I also think it's just a crazy legal overreach as well, too. Just break this down. I mean, we had a rally in Washington, D.C. that turned into a riot, something that was an obstruction of a federal proceeding. But in the past, in United States history, we've had a lot of riots, a lot of unrest. We did not call that an insurrection. And I think really important as well, even the Department of Justice has not charged Donald Trump with an insurrection. There is a statute that allows you to do that in the U.S. Code. Jack Smith is a very aggressive prosecutor. You would assume that if he thought he had any case at all, he would have brought that. He didn't. And that's because there are very technical and legal definitions of insurrections and rebellions, which certainly don't seem to fit here.
Let me just read the text of Section 3 of the 14th Amendment. It says, "No person shall be a senator or representative in Congress or elector of president and vice president or hold any office, civil or military, under the United States or under any state who, having previously taken an oath as a member of Congress or as an officer of the United States or as a member of any state legislature or as an executive or judicial officer of any state to support the Constitution of the United States, shall have engaged in insurrection or rebellion against the same or given aid or comfort to the enemies thereof." So a bit of a mouthful, but Bill, one of the questions would clearly be whether what happened on January 6th qualified as an insurrection or a rebellion. And to my mind, the answer to that is no. And that's a separate question than whether Trump was directly involved in the riot at the Capitol. To Kim's point, if Jack Smith had found some sort of communications between President Trump and the Proud Boys or the Oath Keepers, the people leading this riot, you'd think that by now we would have found out about it, and we still have not had any sort of allegation of that nature.
Yeah, I think the special counsel recognized that it's a stretch because there is no link between Donald Trump and an insurrection. I think he would have been happy to charge Donald Trump with that if he could, but he clearly determined that he couldn't. Look, it's on top of so many other things, using RICO laws, like in Georgia, to go after Trump, so many things. The Constitution has been so debased over the last few years. Even the impeachments, like the second impeachment, they didn't even have an inquiry yet. They went straight to the articles of impeachment. And I think we paid a high price for this twisting of the Constitution and the law. And one of the challenges for Republicans as they confront Joe Biden, for example, on impeachment, is not only to use their powers, but to use them judiciously. And I would say, for example, if they decide to impeach Joe Biden, to have an inquiry first rather than proceed directly to the impeachment. And it's just giving more people doubts about Washington. Not only it's functional, but whether it's honest. So I think Donald Trump may pay a high price for this. I think the country is going to pay a higher price if we continue to twist the Constitution in this way.
Kim, another of the legal arguments, I think, would be whether this disqualification clause even applies to the President of the United States. And just to repeat the first line of Section 3, it's no person shall be a senator or representative in Congress or elector of president and vice president, or hold any office, civil or military, under the United States. And one phrase that's missing there is no person shall be the president of the United States. And you can understand maybe why the drafters might have left that out. If they were operating in the context in the years after the Civil War, maybe it was very thinkable that former Confederates might be elected as senator or representative from those states, but less thinkable that one would be elected president of the United States. But I guess the argument would have to be that the president is covered by implication here, and I'm not sure how that would fare in court.
I just think this gets to Bill's point about what are we doing right now? I mean, we're having all these arcane discussions about whether or not, a section of a post-Civil War amendment is now applicable more than 100 years later to the existing president and what the meaning of is and all of these different provisions. I mean, think about how many conversations we've been having about that lately in terms of the Presidential Records Act and Jack Smith's decision to indict Donald Trump over that, or Jack Smith's decision to take a number of other statutes and really expand the boundaries of them in order to go after Trump over the question of January 6th. It's not a healthy environment to be in. And so, yes, Kyle, that is a very interesting question. Does this even apply to the president of the United States? I think the fact that we don't know that, and that we now have a bunch of legal scholars running around trying to make their best case, shows the somewhat grasping nature of this. And that's what's frustrating here too, is you have to wonder at a certain point when these people are going to work out that when they go to the ballot box and they actually make an argument, they have a chance of winning against Donald Trump. They did it in the last few elections. But if they're going to resort to all these kind of lawfare and collusion claims that they made the last time around, and indictments and impeachments, all it does is polarize the country. And I think puts us in dangerous ground because, again, and I can't stress this enough, whatever you think of Donald Trump, if somebody decides to use this and really take this seriously, it's not going to be long before Republicans are using it against Democrats as well, too. And we really need to stop this downward spiral.